Hi, I'm Annie Fitzsimmons. I'm your Washington REALTORS legal hotline lawyer, and I'm thoroughly enjoying a discussion over Form 22EF with my friend.
My name is Travis Davis. I'm with Coldwell Banker Tomlinson out of Kennewick, Washington. And my hair's gotten a little grayer, by the way. This has taken so long that I've grayed up a little bit. But it's okay. It's worth it.
We don't talk about gray hair. Just FYI. Okay, so we are down to paragraph 3 on Form 22EF. And now I want to talk about how you actually mark the boxes when you're disclosing contingent funds. And hopefully you have a clear understanding of which funds in your buyer's transaction you are going to disclose as contingent funds using the Form 22EF.
Here we go.
So, Travis, the very first box is loan.
Yeah.
I'm confused because in the last video, you have just told us that if the buyer is relying on loan funds and you've included a Form 22A, then you would never disclose those same Form 22A funds using a Form 22EF. So why is the very first box under contingent funds loan?
Well, I would like to think in a perfect world that all families love each other and just gift money away. But there are scenarios in which you may be getting a loan from your parents. And that would be one that would fit that category there and in that situation.
Okay. Anything else?
In a competitive market, you might want to not have a 22A, and the buyer may decide with the broker that, hey, we don't want to have a 22A. We want this offer to be as sleek and clean as possible. And so we might check the loan box here and say that we're going to get a loan, which then puts in some other things into play, which we'll talk about as far as how default is handled in that case.
Okay, so buyer says, I am relying on a loan for 80% of the purchase price, but this is the fourth house I put in a bid to get, and I've been beaten out on every single offer. I do not want to lose this house. Buyer broker, help me figure out how to make my offer as competitive as possible.
So what things go away in that situation? I mean, can I have an appraisal or not? It talks about the paragraph, and Annie's going to get into that in a little bit about the appraisal, but the low appraisal provision would go away. You wouldn't have a low appraisal provision if you structure it that way.
Okay. So from the buyer broker, so let's go ahead and talk about those boilerplate provisions, because I think it's really important for buyer brokers to understand the conversation they need to have with their buyer. Because yes, buyer, you make your offer more enticing. Why do you make your offer more enticing? Because you don't have a contingency if you're unable to get your financing. So some buyers want to take that risk and will say, look, no Form 22A, no financing contingency. Yes, I do have to get a loan, but I'm extremely confident in my own ability to get the loan. And I'm even confident that the property is going to appraise high enough. And so I'm willing to take that risk. But buyer brokers, you've got to have a tough conversation with your buyers. Your buyers should never go in thinking that the evidence of funds addendum is a contingency addendum, because it's not. You're disclosing contingent funds, your reliance on contingent funds, but there is no protection in this form if your buyer is unable to obtain that contingent source of funds. So if your buyer wants to do what Travis just described, rely on a loan, but not rely on a contingency, a financing contingency, then Form 22EF, paragraph 3, first box, loan, is the right box to mark. But buyer broker, have a tough conversation with your buyer about the risk that includes. Document that conversation in writing. In other words, write an email to your buyer afterwards. Follow up with your buyer about that conversation. Confirm their advice to you that they want to make an offer relying on a contingent, relying on loan funds, but not relying on a financing contingency, and get a reply from your buyer confirming that that's what they want to do, so that you can keep that communication in your firm's transaction folder going forward. Okay, so picking up on what Travis was telling you I was going to get to, I don't want to make him a liar, so let's get to that. Lines 29 through 34 of Form 22EF are really important for you to understand. These lines say that blank number of days, 10 days by default, before closing. So this timeline works exactly backwards from every other timeline in the statewide form system. Almost every other timeline starts at mutual acceptance and moves forward. This timeline, set forth on lines 29 through 34 of Form 22EF, start at mutual acceptance and work backwards. And start at the closing date. I'm so sorry. They start at the closing date and move backwards and say that 10 days by default, buyer must prove to seller that buyer has whatever the disclosed contingent source of funds is. So, and buyer brokers, you simply cannot just allow the default language to go forward without thinking through the ramifications of that in every single transaction where you include a Form 22EF. And this loan provision is the most obvious example. Travis, I'm your buyer. I've said I don't want a financing contingency. I am relying on an 80% loan. You pull out 22EF, you mark the loan box. How are you going to mark the blank on line 29?
Well, loan funds aren't available usually till the day of closing, right? And that's usually the way it works, somewhere in there. So I'm going to put 0 in that line because I know those funds will be available really close to closing, if not the day of closing. So that's how I would fill that out.
I agree. And what is the significance, Travis, if you erred? If you just left that blank, and so the default was 10 days, what would be the ramifications of that to me as your buyer?
Once the 10-day clock starts, so we go back and we've got the 10 days now till closing, and my buyer has not supplied the seller with notice that we have the funds or the funds are in our account at that time. The seller has the right to terminate the agreement. And if the seller terminates under that provision, then the buyer would be entitled to their earnest money back in that scenario.
But they lose the house.
They lose the house.
Yeah. Buyer brokers, please understand the importance of that blank space. And it's going to really, you are going to have to engage mentally on that blank. It's one that you cannot rely on the default of 10 days. Because if you rely on the default of 10 days and you've marked the loan box and your buyer's got to get a loan, using the seller's property as collateral, you are never going to have those funds prior to the day of closing.
Yeah. And it's super important also, if you do check the box that the buyer's saying, I'm going to get a loan, I'm not using the financing addendum, but I'm going to get the loan, for lines 35 through 37, allow the seller shall permit the appraisal of the property, allow access for any lender required inspections and the appraiser to come in. So there is that language in there that does kind of work in the buyer's favor for checking that box on the loan.
Yeah. The value of those lines can't be overstated if your buyer's relying on a loan, because your buyer's got to have an appraisal of seller's property, right? Mm-hmm. And until those lines were just added in a recent revision of the form, well, recent now being 2 or 3 years ago, but before that, buyers would rely on a loan, and then they wouldn't have the authority to be able to get an appraisal done on seller's property. So those boilerplate words between lines 35 and 37 that Travis just identified, critically important if the buyer is relying on institutional financing using seller's property as collateral to fund the property, but not relying on a Form 22A. Okay, that's one box.
That's one box. There might be 5 more videos.
I'm really torn as to whether or not we break here. I'm going to say that. Let's end here because this was a long video. We're going to finish this form in the next video. I'm confident of that. But we do have to spend a fair amount of time talking about the very next checkbox. And so let's
Absolutely.
break here, make a 5th video on Form 22EF, and really be able to go thoroughly into all of these provisions. And then we'll be done.
Sounds good.
If you have questions on anything we've covered in this video or any other real estate law topic in Washington State, send an email to me, legalhotline@warealtor.org. Thank you for being a Washington REALTORS member.